Hi everyone, today my presentation is about the Auckland Trotting Club versus CIR case. First, let's say what happened in this case. The Auckland Trotting Club constructed a new shear track of 5 furlongs in place of its existing shear track for the purpose of holding totalizator trotting meeting during the night. The first racing on the new shear track took place in September 1960. Even during this first meeting, there were ominous signs that the track might prove unsatisfactory. People doubted that whether or not it would compact properly, but the engineer in charge of the work assured the club that ultimately it would. After being used for approximately 12 months, the track was complained to be a danger for both horses and the drivers racing upon it. Because of the shifting state of the surface. After discussing with other engineers, the club decided to hire Mr. Hauser to be in charge of the construction of the new track. The constructors first removed the first layer of shear and sand. A subgrade of scoria under the top layer was removed by the constructors as well, until only traces of it remained, except at the bends. Further excavation was done to ensure that certain of the foundations were made secure. The contractors then strengthened the foundation with rotten rock, constructed a subgrade of rotten rock, applied a base course, then a top course of metal, and finally put a layer of limestone. This contract also included the provision of certain drainage. But no difficulty arises over this because the club all along treated the cost of this as expenditure of a capital nature. The other work, including the replacement of a retaining wall and the running rear, cost $29,969. And out of this total sum, the work done in connection with what were found to be unsuitable foundation accounted for $6,399. For the year ended 30th June 1962, the club claimed a deduction of the total sum of $29,969 under the heading Repairs, Maintenance, and Alteration. The commissioner just refused this deduction. And the question here is, did the commissioner act incorrectly in disallowing the deduction, and if he did, in what respect should the assessment be varied? And the legal issues in this case is what is the premises, and is this work repair or reconstruction, and finally whether the cost is deductible or not. To answer these questions, the judge first looked at this section 110 to section 113 of the Land and Income Tax Act 1954. In the subsection 111, in calculating the assessable income of any person deriving assessable income from one source only, any expenditure or loss exclusively incurred in the production of the assessable income for any income year may, except as otherwise provided in this act, be deducted from the total income derived from that year. In section 112, it is mentioned that the money used in the improvement of the premises occupied was not deductible. And furthermore, in subsection 113, notwithstanding anything to the contrary in the section 111 of this act, in calculating the assessable income derived by any person from any source, no deduction shall, except as is expressly provided in this act, be made in respect of any of the following sums or matters, namely the repair of premises, or the repair, alteration, or supply of plant, machinery, or equipment used in the production of income, beyond the sum usually expended in any year for those purposes. It is also said that the Commissioner is satisfied that Any repairs or alterations of any such asset do not increase the capital value of the asset, or that the repair or alteration increase that value by amount less than the cost of the repairs or alterations, such deduction may be allowed. The judge then considered about what is the meaning of the word repairs in connection with matters of taxation. He first looked at the Lurcourt case. In that case, Judge Buckley said, repair and renew are not words expressive of a clear contrast. Repair always involves a renewal of a part of a subordinate part. He also gives us some examples. A roof falls out of repair. The necessary work is to replace the decayed timber by sound wood. Part of a garden wall tumbles down. Repair is effected by building it up again with new mortar and, so far as necessary, new bricks or stone. Repair is restoration by renewal or replacement of subsidiary part of a whole. Renewal, as distinguished from repair, is reconstruction of the entirety, meaning by the entirety not necessarily the whole, but substantially the whole subject matter under discussion. Then the judge checked the meaning of alterations. The judge agreed with what the chairman of the board of review said in the club's early case. In the shorter Oxford English Dictionary, alter is said to mean to make otherwise or different in some respect without changing the thing itself, to modify. The chairman also looked at the church's case and the settled estate case. Both judges in that two cases thought that the erection of a new building in place of an old building is not an addition to or alteration in that old building. Then the chairman concluded that the word alteration may, in appropriate circumstances, refer to a repair or renewal incidental to the making of something otherwise or different in some respect without changing the thing itself. However, that the question about alteration in every case is about one of a degree, and that the test to be applied is whether the act done is in substance an alteration in part only or a replacement of substantially the whole. Then it connected to the next question, the entirety versus subsidiary test. To answer this question, the judge used a two-stage approach. First, find out what constitutes the premises, then find out what is the nature and extent of the work has been done. If the work has been done was repair, one must decide whether it is a renewal or replacement of defective parts, or it is a reconstruction of subsidiary the whole subject matter. And if the work done was an alteration, it is necessary to decide whether it is merely a modification making the premises different in some way without changing the thing itself, or it was a replacement of substantially the whole. The judge said that some repairs may carry with them certain of the characteristics of alterations, and that some alterations may incorporate repairs, but any such overlapping will not affect the type of approach that should be made to the questions. So, what is the subject matter under the consideration in this case? On behalf of the club, two alternative submissions were made. The first was that premises should be regarded as the whole of the club's undertaking, that is to say, everything within the boundaries of its property, including such things as boundary fences, grandstands, totalizator buildings, race tracks, restaurants, car parks, horse boxes, and lawn. On this basis, the share track itself was a comparatively small portion of the premises, and that what was done in connection with it affected nothing more than a defective part and did not affect substantially the whole. The alternative submission was that the premises were racetrack itself, including sheer track, the dirt track, the rears, and the floodlighting, everything within the out-rear. In those circumstances, the work did not affect substantially the whole subject matter because certain of the rears and especially the floodlighting were not involved. Because of the significant initial cost, the floodlighting is a very substantial part of this particular entirety. To decide what constitutes the premises in this case, the judge referred to several cases. The first one is case number 617, which involved a racecourse, raising problems similar to those in the current case. This undertaking is a racecourse. It embraces several distinct units, buildings such as stands, totalizers, stables, refreshment rooms, etc. The property as a whole requires being fenced for the purpose of excluding persons who have no right of admission. In this case, the fencing around the course is considered to be not a separate subject matter, but a subsidiary part of the racecourse. Then the judge referred to another case. In the colliery's case, the colliery company replaced an unsafe chimney with a new one. The new chimney was erected on an adjacent site and was admitted to be an improvement upon the old one. Judge Rowlatt said in that case, I don't think it is possible to regard that as repairing a subsidiary part of the factory. I think it is simply having a new one, and they had them both. Perhaps they pulled down the old one, perhaps they kept it, because they thought it was an artistic thing to look at. There is no accounting for tastes in manufacturing circles. Anyhow, they simply built a new chimney and started to use that one instead of the old one. I think the chimney is the entirety here and they simply renewed it. However, there is another case which also involves a chimney but comes to a different conclusion. In Samuel Jones' case, the company carried on the business of processing paper. A chimney at its factory had become dangerous and had been replaced. The replacement being close to the old one, but however not constituting an appreciable improvement over it. As far as function was concerned, the suitability of the new chimney was exactly the same as that of the old one. The learned Lord President said in that case, as far as this case is concerned, the factors seemed to me to demonstrate beyond a doubt that the chimney with which we are concerned is physically, commercially, and functionally an inseparable part of an entirety, which is the factory. It is quite impossible to describe the chimney as being, in the words of Rowlatt said, the entirety. It is doubtless an indispensable part of the factory, doubtless an integral part, but nonetheless a subsidiary part and one of many subsidiary parts of a single industrial profit-earning undertaking. Then, in a later case, Philip's case, the judge in that case compared the two cases above and said, in my judgment, the premises for the purpose of Rule 3D may sometimes be the whole of the trader's business premises, and may sometimes be a specific building forming part of those premises. If, uh, if a factory window were blown out and had to be repaired, in such a case, the premises would be the entire factory, in relation to which the window would be repaired and nothing else. But, for example, if a retort house in a gasworks was destroyed and had to be rebuilt, one would hardly call that a repair to the gasworks. The size of the retort house would compare one to regard that as the premises for the purpose of Rule 3D, and since it had been replaced in full, it could not be said to have been repaired. These examples illustrate what I think is the truth that there is no one line of approach to the problem which is exclusively correct. In some cases, it will be right to regard the premises as the entire factory, and in other cases, it would be right to regard the premises as a part of the factory. Whichever alternative is the right one to adopt will depend upon the facts of the particular cases. Another two cases had been referred in this case are the Margaret's case and the Lindsay's case. The Lindsay's case is a very interesting case. The taxpayer in that case owned two slipways. One of the two slipways was reconstructed. Slipway 1, as reconstructed, extended further than the original slipway, but the cost of this extension was not claimed as a deduction. Moreover, reinforced concrete had been used to replace the previous timber structure because suitable timber was unobtainable. However, evidence was given that, as regarded cost, there was no substantial difference between the two materials, and that even in point of durability, concrete offered no advantage over timber. But George Kittle had that the slipway was an entirety by itself, and that the work done constituted a renewal of that entirety and not a repair. After looking at all these cases, the court in this case thought that first, the physical thing which here satisfies the motion of a premises is the shear track itself, and not any larger thing or aggregation of things of which it may be suggested to form part. Secondly, the amount sought to be deducted by the club was incurred by not by the way of repair or alteration, but by the construction of what was substantially a new track in place of what was substantially the whole of the old track. Therefore, the amount is not deductible. Basically, I agree with the judge's decision in this case. As the judge said in the Phillips case, the premises may sometimes be the whole of the trader's business premises, and may sometimes be a specific building forming part of those premises. There is no one line of approach to the problem which is exclusively correct. Whichever alternative is the right one to adopt will depend upon the facts of the particular case. In this case, I think the track itself is divisible from the rest of the undertaking. Considered its size and the significant cost, it is the subject matter we are dealing with. And what has happened to the case substantially? I think this case has provided a reference for later cases when it comes to the question relates to premises, and also the two-stage approach used in this case maybe provide approach for the later cases. Yeah, that's basically all about my presentation. Thanks for watching.